Good morning, everybody. Welcome to the Greens List breakfast briefing this morning. For those of you who don't know me, my name's Phil Corbett. I've been a member of Michael's List since inception, so I've trained him up well, I think, by now. But Michael's in the back and is no doubt happy to speak to any of you towards the end of the seminar this morning. Our two speakers today are Kane Loxley, who's going to deliver a paper on Calderbanks letters, and then Chris Hanson, who will talk about offers of compromise. Have I got that around the wrong way? So, brilliant. Other way around. Kane Loxley is going to talk about offers of compromise, and then Chris on Calderbanks letters. And then also both are going to discuss some of the potential reforms that are happening in relation to both and costs generally. Kane's background, for those of you who don't know him, he came to the bar in May of last year, and prior to that he was a solicitor at Freehills in Sydney and Melbourne, and then associate to Justice Simon Whelan in the Supreme Court. He practices in the commercial field mainly, but also I think prepared to take anything. Certainly does some criminal work as well, but at the moment a generalist, but with a bent towards commercial and civil litigation. Chris has been at the bar now since May of 1999. He's also a commercial person, although specialises in insurance law, and he's a very busy member of our list. So he's also an accredited mediator, nationally accredited mediator, and also has written a number of papers which you can find on the Greens List website if you've got access to that, which I hope you all do. And you'll see his papers there on witness statements and what to do when the regulator comes knocking, which was a seminar he presented with Simon Rubinstein. He's also done papers on insurance contracts and disability claims on super funds. So without more, I will ask Kane to deliver his paper. And as I said, if you've got any questions, just ask them in the running, or we'll have a session at the end. Thank you.
Thanks, Phil, and thanks for braving the wintry conditions this morning to be here. As Phil said, I'm going to focus on offers of compromise. In particular, I'm going to focus on Order 26 under the state rules. Now, Order 26 applies both under the Supreme Court rules, the County Court rules and the Magistrates Court rules. Now, there are offers of compromise regimes at the Federal Court and in VCAT, but there are some important differences between the three. And in the schedule to my paper, which I don't think I'll get time to refer to in detail today, but I've set out some of the key aspects of each regime and some of the differences, and I'll touch upon a couple of the key ones. Offers of compromise have been described as being fairly mechanical in nature, and I think that's a pretty useful description. They're mechanical by reference to both the usual discretion or wide discretion the court has on costs. They're mechanical by reference to the wide discretion that applies to Calderbanks letters that Chris will touch on. They're also mechanical in the formal requirements of an offer. Courts are quite strict on compliance with those formal requirements, and if you don't comply with them, the offer will be deemed to be invalid and the consequences that you hoped for won't apply. And the other way, of course, in which they are mechanical is they do set up these defined cost consequences. Those cost consequences are set out in Rule 26.08, which I set out on page 2 of the paper there, and I'll just go through them. It changes, of course, depending on whether it's the plaintiff making the offer or the defendant, but where the offer is made by the plaintiff and not accepted by the defendant, 26.08 provides that if the plaintiff then equals or betters the offer at judgment, the defendant will pay costs to the date of the service of the offer on a party-party basis, but then from the date of the offer to judgment on an indemnity basis. Now that applies to all proceedings except for personal injuries or cases of death, where in that instance, if the plaintiff makes the offer and the defendant doesn't accept it, then all costs incurred in the course of litigation will be payable on an indemnity basis. Now, I haven't referred to it in my paper, but there was a recent case in the county court where, it was appealed to the Supreme Court, but it was a personal injuries action in the county court, and the plaintiff's case had been closed. The defendant opened their case, and just prior to calling evidence, the plaintiff made an offer of, for argument's sake, $150,000. The defendant rejected that offer, proceeded with their case. Judgment came back for a sum greater than the $150,000. The court, or the county court, awarded all costs payable on an indemnity basis. The defendant appealed to Justice Dixon in the Supreme Court and said that that offer wasn't a genuine attempt to settle the dispute, but rather it was simply setting up the foundation for an argument on indemnity costs, given that it was halfway through the case and it should have been made at an earlier offer. Justice Dixon rejected that argument and said that it's not a relevant consideration when the offer is made or whether it's made during trial or prior to. The defendant still had to consider the offer on its merits, and they had to assess their risk, and they decided not to accept it, and therefore they were up for the full whack of indemnity costs. I'll just pause to note that the reason that there is this carve-out for personal injury actions is that it's considered that the defendant usually is a corporation or has deep pockets, and the plaintiff in these cases doesn't, and so the legislature saw fit, I think, to try and equal the bargaining power so that a plaintiff who makes an offer, the defendant is under more pressure to accept it. So that deals with offers made by plaintiffs. Turning now to where an offer is made by a defendant, where that offer is made and the plaintiff doesn't accept it and then fails to beat the offer. So again, if they equal the offer, they're okay, but if they don't beat it, the defendant will again have to pay the plaintiff's costs on a party-party basis to the date the offer was made, but then the plaintiff is liable for those costs, or the defendant's costs rather, from the date of the offer to judgment. Under the Order 26, so the state rules, they're liable on a party-party basis, but as I referred to at the start, there are some differences in the regimes, and this is a key difference between the federal court and the state rules, because under the federal court, the plaintiff will have to pay the defendant's costs from the date of the offer on an indemnity basis, which is quite telling when you consider that if a plaintiff is still successful in their action, so say the defendant makes an offer for $150,000, the plaintiff gets judgment for $100,000. In the usual course with costs following the event, the plaintiff would still be able to recover their costs from the date of the offer, all their costs in the proceeding. But where the defendant makes this offer and it's rejected by a plaintiff, in the federal court, not only do they forego what they would usually, the right to recover their costs from a party-party basis in the whole proceeding, but they're all of a sudden liable for the defendant's costs on an indemnity basis from the date of the offer. So it's really important, I think, to keep in mind when you're acting for a plaintiff and you receive an offer from a defendant, particularly in the federal court, that you could be up for a serious whack if you don't accept the offer and you don't beat it. I said before that there are these defined cost consequences under 26.08, and I've just set them out. It's almost always the case that the court, provided that the formal requirements are complied with, the court will follow those consequences. But there is a carve-out in the rule that says unless the court otherwise orders. So there is this residual discretion. Now, the phrase unless the court otherwise orders has been construed to require either special or exceptional circumstances. An example of exceptional circumstances in a New South Wales case was where there was a change in the law as to whether damages for loss of a chance were recoverable in a medical negligence case, and that change in the law occurred between the date the offer was made and the date judgment was delivered. And so the court said, well, it's not apples and apples. The context is very different from when the offer was considered to when judgment was delivered, and so it was held that the consequences under the rule didn't bite. But as I say, it has to be something of that nature, or Chris mentioned to me before an example like discovered documents are made after the offer is made, which completely changes the complexion of the case. But generally speaking, unless you've got something that's changing markedly, if you make an offer in compliance with the rules, the court will apply the consequences as set out in 2608. One aspect that I'll just touch on briefly, and it's at paragraph 7 of the paper, is the notion of whether in rejecting or accepting an offer, or rejecting an offer rather, you need to be reasonable. And there's a little bit of conflicting authority on this that arises out of a case in 2010 where it's Justice Croft, the cases 10th Vandy Proprietary Limited and NatWest Markets. Justice Croft observed that neither an offer of compromise under Order 26 nor a Calderbank, quote, will have any cost consequences unless the rejection of the offer was unreasonable in the circumstances. Now, Chris, of course, will talk about reasonableness because it has real application to Calderbanks, but that case, and in particular that comment by Croft, was relied upon by the appellant in a case later that year before Justice Vickery, Charles Blackman and others. And Vickery was, as polite as possible, quite critical of Croft's reasoning, particularly on the basis that he didn't distinguish between Order 26 and Calderbanks, and in particular didn't distinguish between this presumption that I've referred to where you have the entitlement, provided the formalities are complied with, to have your costs assessed on the prescribed basis in 2608. It's not at the discretion of the court. And so Vickery said that by not having proper regard to those differences, in effect, Croft had fallen into error. Vickery said that it's just one possible circumstance the court can... Vickery said that reasonableness, so whether the offeree has been reasonable in rejecting it, is just one circumstance that the court will consider on whether to depart from the defined consequences. But as I said before, it seems like it's unusual, and generally speaking, they follow them pretty religiously. Moving on to the formal requirements of an offer, and I'll deal with these relatively quickly. The first is very straightforward in that you've just got to make sure that when the offer is written, and I'm at page 4, paragraph 9, that when the offer is made, that it clearly states that it's in accordance with the order, and it also must comply with, or it's a formal court document, so it must comply with the formalities in Order 27, namely that it have a heading and have information, the tram tracks and so forth. Now the second formal requirement, and this is unique to Office of Compromise, and it's also unique to the state rules as distinct from the federal again, but if you're making an offer of compromise under the state rules, it must be exclusive of costs. Now this requirement flows from the fact that under Rule 26.03 subsection 7, the rules say that upon an offer of compromise being accepted, the defendant must pay the party costs of the plaintiff up to and including the date the offer was served. So you've got the rules expressly providing what the costs must be, and following that sub-rule, Rule 26.03 sub-rule 8 provides that if the offer contains a term which purports to negative or limit the operation of the preceding one, then the term shall be of no effect for any purpose under Order 26. Now this is important because it means that if you make an offer and you want it to be an offer of comp and have the consequences I've referred to, but you make it in an all-in fashion, so you say in full and final settlement or inclusive of costs, the court will strike it out and it won't be held valid. It might be construed or considered a Calderbank, but you've got no certainty of that being the case. And so if you're wanting to make an offer under the state rules, you must make sure that it's exclusive. Now, this was also recently considered in the Court of Appeal, where at trial, the plaintiff received judgment for $131,000 and their costs on an indemnity basis because they had served an offer of comp for $145,000 plus costs. But importantly, the defendant in that case had made, 1, an offer of a greater amount, and 2, an offer prior to the plaintiff's offer but they'd made it and expressed it in this way: in full and final settlement of its claim. The trial judge rejected the defendant's offer as being costs inclusive in accordance with Rule 2603(8), and therefore not a valid offer, and so awarded costs for the plaintiff. Now, the defendant probably rightly was a bit miffed, given they'd made an offer for one, more money, and two, earlier in time than the plaintiff, and so appealed it to the Court of Appeal. And the defendant argued that its offer for full and final settlement didn't convey that it was inclusive of costs, and that it really shouldn't be distinguished from the plaintiff's offer being plus costs. But Justice of Appeals Priest rejected that and said that the plus costs expression clearly sets the costs outside the offer sum, whereas the expression full and final settlement is an all-in offer and it couldn't be hived off. So to avoid a situation where you're falling into error and your offer of comp won't be upheld, and it seems like it's quite an unfortunate consequence for the defendant in this case, but I would say if you're wanting to make an offer under Order 26, expressly state that it's exclusive of costs, even though in the case I just mentioned, plus costs was held to be valid. There is some contrary authority in New South Wales where under the analogous rule, it's been held that plus costs is also in breach of this requirement that it not include costs. So I think the most prudent course is to make it expressly exclusive if you're wanting to make it under Order 26 and if you're wanting those consequences to apply. Again, this is another point of difference to the federal court. If you're in the federal court, you can make an offer that's inclusive of costs, but you must clearly state that it is so. Two more formal requirements that I'll touch on briefly. The offer must be open for not less than 14 days from the date it's served on the other party. Otherwise, the length of time the offer is open for is at the offeror's discretion. If the offer doesn't specify a time, it will lapse after 14 days. And also, once the offer is accepted, payment must be made within 14 days of that acceptance, unless the offer specifies otherwise. And the fourth and final of the formal requirements is that unless the offer is clearly not made on a without prejudice basis, then no disclosure of the offer's existence can be made to the court, notwithstanding that it seems like a formal court document and you might be inclined to think you should serve it, but under no circumstances should it be served with the court, and it shouldn't be disclosed unless it's not without prejudice.
Does that mean you can still serve it with a denial of liability, or is that then we're saying we're offering X amount of dollars plus costs,
Yes.
making it an open offer, but we're saying this is not a admission of liability?
Yes.
So we're not using it without, it's the same.
I think it's at the same effect, that's right. And yeah, it's really, it'd be a matter for you as to whether you wanted to disclose it to the court, but I would have thought that if you use those terms, it'd have a similar effect to without prejudice.
So you've got a complete open, so it's an admission of liability.
No, I don't really follow how to be an admission of liability.
There'd be no determination on the merits, so it should be none.
So you're not prejudicing your case by making it, where you're admitting you've done something wrong?
I would have thought so.
No, I wouldn't think so. There is a different regime for appeals, and it's a more flexible regime than at trial. The formal requirements I've referred to don't apply to an offer made in respect of an appeal. Simply, it has to be in writing and it must be open for a reasonable time. And the court may take the offer into account when determining costs, but it won't have those defined consequences that apply at trial. And so in a way it applies probably similarly to a Calderbank. And importantly, there is authority that says an offer made under Order 26 at trial won't apply to costs incurred from trial to appeal. So you should certainly make a fresh offer if you're wanting to protect yourself in respect of an appeal. And finally, just touching on it, there's been some discussions of reform in this area. I can't at the moment ascertain whether there's been any drafting instructions to Parliamentary Council or the like, but a couple of years ago, the Victorian Law Reform Commission recommended that the Department of Justice undertake a review of Order 26. I understand the consultation process of that review has been undertaken. there was a recent article in the LIJ that discussed some of that consultation. Just wanted to touch on a couple of the areas of mooted reform. One is, and I referred to this a bit earlier, about it being somewhat unfair on plaintiffs that not only are they foregoing the costs they would otherwise be entitled to, but all of a sudden they're up to pay the defendant's costs from the date of the offer. So I haven't seen any legislation or drafting as to how they would change those consequences, but there is talk about trying to make it more equitable. And the other way that it's been discussed that the rule or Order 26 could be reformed is to make it more consistent with the federal court rules, and particularly around this issue of cost-inclusive offers. There was a quote in the LIJ article, and I've extracted it at page 7 there, where a survey conducted of a number of lawyers, the result of that survey was that their clients preferred cost-inclusive offers because this removed any uncertainty as to future costs, liability, and if accepted, allowed the case to be resolved immediately without the need for negotiation or taxation of costs. Now, to my mind, that makes a fair bit of sense, and I can see why that would be the case. But one place where a cost-inclusive offer is certainly permissible is when you want to make a Calderbank, and on that note, I'll hand over to Chris Hanson, who will deal with Calderbanks. Thanks.